Welcome to Module 5, Legal Basis for Processing. The first GDPR principle states that data should be collected for specified, explicit and legitimate purposes. At the end of this module you will understand the legal basis for processing personal data. Question: you are on holiday alone and have an accident and need immediate surgery. The hospital is unable to ask you for your consent to obtain your medical records from the UK, so go directly to the NHS to request your information. Is the NHS allowed to provide the hospital with your data? Answer at the end of this module. Legal basis for processing. The first GDPR principle states that the data should be collected lawfully. The regulation gives 6 legal bases for processing personal data. 1. Consent. Consent from the data subject for a specific processing purpose. Consent must be freely given, specific, informed, unambiguous, and is more rigorous when related to children. Consent for special categories of data must be explicit, meaning a very clear and specific statement of consent. Consent is specific to the use stated, so if the data controller wants to use it for something else, they need to obtain updated consent. The data subject shall have the right to withdraw their consent at any time, and it should be as easy to withdraw as to give consent. 2. Contracts. Where the processing is necessary for the performance of a contract, or where the processing is required to enter into a contract. Where there is a contract between the data controller and data subject, and the processing is necessary for the data controller to complete the contract, or if the data subject requests the processing to enter into a contract. For example, if a person books a hotel in another country via booking website, then the data controller will need to use their data, including financial details and passport information, to make the booking. 3. Legal obligation. Compliance to a legal obligation to which the controller is subject. For example, an employer has a legal obligation to provide payroll information to HMRC. 4. Vital interests. Protection of the vital interests of a data subject or another natural person. For example, provision of your medical records to a hospital without your consent, if you are not in a position to provide that consent. This base should only be used in an emergency. 5. Public interest. Necessary for the public interest or the exercise of official authority of the controller. For example, using data for research and statistical purposes, or collating censuses. 6. Legitimate interest. As necessary for the legitimate interests of a controller or a third party, unless this impacts the rights and freedoms of the data subject. If an organization needs to process data to pursue its business, then it can use legitimate interest as the legal basis for processing, as long as it does not impact the rights and freedoms of the data subject. In addition, the data controller needs to justify the use of legitimate interest, rather than saying this is in my legitimate interest. This is achieved by applying a 3-step test and documenting the results. The data subject shall have the right to withdraw their consent at any time, and it should be as easy to withdraw as to give consent. The 3-step test requires an organization to consider the following. The purpose test, define the legitimate interest. The necessity test, consider if the processing is necessary. The balance test, consider the data subject's interests. Answer to the question at the start of the module. The NHS can provide the hospital with your personal data based on your vital interest. However, the hospital must demonstrate that they could not get your consent and there was no one else present who could authorize their request. We will now ask you 2 short questions. Some time will be left for you to think about the answer. However, feel free to pause the video after the question is asked to allow yourself enough time to think about the answer. You do not need to click on the boxes to provide your answer. The answer will be given shortly after the question has been asked. Consent is not always considered the best legal basis for processing data. Why is this? Consent is not a legal basis for processing data. A data subject cannot withdraw consent once it has been given. Consent cannot be used if health data is involved. Consent is specific and would need to be refreshed each time the purpose of the processing changes. Consent is specific and would need to be refreshed each time the purpose of the processing changes. An organization can use legitimate interest as the basis for collecting and storing data as long as the rights and freedoms of the individual are not impacted. There is no other way for the organization to complete the processing. That the company agrees this is acceptable with the Information Commissioner's Office. That the legitimate interest will benefit the organization. The rights and freedoms of the individual are not impacted. This is the end of our Module 5, Legal Basis for Processing. You can now move on to Module 6, Data Subject Rights.